Good afternoon, everyone. Thank you for joining us for today's online talk. Our talk will be starting shortly at around 3 p.m. For those of you who are here early, thank you for waiting. While waiting, we would like to share with you a short video from the firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk entitled Understanding Probate Disputes and Resolving Contentious Probate Proceedings. My name is Wong Chi En. I am an associate with Ma Wing Kwai & Associates, and I'll be your moderator for today's session. Before we begin today's talk, let me introduce the firm and what we do. Ma Wing Kwai & Associates is a mid-sized law firm that was founded in 1985 by Datuk Ma Wing Kwai. Our able team today comprises 27 lawyers and a support team of 25. Datuk Ma today is a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with small, medium enterprises, SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department including litigation, adjudication, and arbitration, a dedicated employment industrial relations team, as well as a department focused on servicing the needs of individuals and families. We have various practice groups here, as you can see, indicating some of our focus areas which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWKA online talks series. Just a bit of background, been organizing lunch talks at our office since 2013, some of which were broadcasted live. Since the implementation of MCO due to the COVID-19 pandemic, we have moved our talks online in order to continue with our objective of sharing knowledge, raising awareness, as well as encouraging networking for clients, potential clients, as well as in-house counsel. Recently, we had a talk on the 9th of June that was a topic on navigating divorce obligations, insight on varying and enforcing decree 9 orders. And we will have another one in the end of July, 26th of July, legal challenges in the dynamic world of technology. Before I continue, please be reminded that this talk does not constitute legal advice. In the event that you require any specific legal advice to your matter, please contact us for a complimentary legal consultation. We will give you further details regarding this at the end of the talk. All right, without further ado, let me introduce our speakers today. We have two speakers for today's talk. The first one is one of partners in the firm, is Choo Man Wei. Man Wei is a partner in our dispute resolution team. She holds a Bachelor's of Law from the University of Manchester, UK. She has been involved in advising a wide ranging of cases, including contractual, estate, and intellectual property disputes. Currently, her areas of practice includes general litigation, land disputes, and estates, including both contentious and non-contentious matters such as will writing and also grants of representation. Our second speaker for today is also a partner in the firm, Mr. Gan Chong Chieh. He's also a partner in the Dispute Resolution Department. He holds a Bachelor of Laws in University of London. He also has a Masters of Law, LLM, in International Economic Law from East China University of Political Science and Law. He was admitted to the Malaysian bar in 2009 as well. And his areas of practice is also wide-ranging, includes general litigation, will writing, probate administration, contentious probate litigation, banking litigation, debt recovery, arbitration, construction, family law, criminal law, and as well as JMB disputes. I will now pass on the floor to the first speaker of today, which is Man Wei. Man Wei, over to you.
Thank you, Choo, for the introductions. So today, based on the topic, some of you must be wondering what is contentious probate proceedings. So our top points are as follows. We will start with a brief introduction on what exactly is contentious probate proceedings, as well as an introduction on some basics about wills. And then we'll move on to two types of contentious probate proceedings. Today, we will be focusing on two types. One is an action to invalidate a will, and then secondly, an action to remove an executor. And then after that, we will end with some briefly touching on other useful tools in contentious probate proceedings, namely caveats and citation proceedings. Now, before I move into the slides, let me just go through some terminology that we will encounter as we go along in today's talk, which may sound a bit strange to the uninitiated. Okay, firstly, we are talking about wills today. Everyone should know what is a will. Well, and a testator is the person who made the will, the person who's signed the will, who's willing away his assets to beneficiaries. The executor named in the will is the person who will carry out the wishes of the testator. Now, probate, what is probate? Essentially, probate is a court order. It's just a simple one-page document, essentially, granted by the court, which gives power to the executor to carry out the wishes of the testator according to the will. The beneficiaries are the people who stand to inherit the testator's assets according to the will. Now, what then is contentious and non-contentious probate proceedings? To understand more on contentious probate proceedings, I find it useful to explain what is a non-contentious probate proceedings. It's basically a standard or regular probate proceedings after someone passes away with a valid will. His executor then applies to court for the grant of probate for the court order we mentioned just now. And upon obtaining the grant of probate, an executor, the next thing to do is to call in the assets, which means to transfer the assets from the name of the testator into the name of the estate, and then distributes the assets. By distribution, we mean to distribute the assets to the beneficiaries according to the will. So in a non-contentious setting, all this will occur uneventfully. There's no disagreement or contest from any parties. So a procedure for the non-contentious probate proceedings is covered by Order 71 of the Rules of Court 2012. Now, how about contentious probate proceedings then? With contentious probate proceedings, there are various disagreements in the different stages of probate. Firstly, perhaps parties could not agree on who is to be executor, or an executor is appointed and then the parties are not happy and they wish to remove him and the like. There's also lack of consensus on whether the will is valid and whether the instructions in the will are to be followed. Now, whether the will is valid, perhaps is it genuine or is it forged, or what are the circumstances under which the will are made to make it valid or otherwise. And there's also a lack of consensus on the manner of distribution of assets. Perhaps the beneficiaries are not happy with the manner of distribution described in the will. So contentious probate proceedings are governed, the procedure is governed by Order 72 of the Rules of Court 2012. Now, I'll pass on the next section to my partner, Mr. Gan Chong Chieh, who will speak on, firstly, the basic formalities of a will.
Thank you, Chien, for the warm introduction. Thank you, Man Wei, for the introduction. And also, thank you to all participants for taking time to attend today's talk. I will continue with the formalities of a will. I guess it's important that we do understand what are the formalities. More often than not, the starting point to actually mount a challenge on a will by any practitioners most often than not, they will scrutinize whether the will, or even codicil, whether has it actually met the formalities provided for under the Wills Act of 1959. Without further ado, let's dive into what are the formalities or what are the basics that we need to know in order for a will to be valid. So under Section 3, the maker of the will must be of sound mind with animus testandi. That means, really, in layman's term, you must have testamentary capacity to actually prepare or draft out the will. Next would be the testator or the will maker must be 18 years and above. And under Section 5, of course, there's the manner where a will has to be done. If not, it will not be valid. And after this, we will go into Section 5 and to see what really is the manner prescribed under the state provision. So under Section 5, really, once you have the will prepared, the body of the will prepared, the signature of the testator has to be at the foot or the end of the will. And subsequent to that, the signature of the testator must be in the presence of two witnesses. So both witnesses must sign after the signature of the testator. So in the so-called will, you have the signature of the testator at the foot of the will. And then after that, you have the signature of the two witnesses. And bear in mind, while the testator is actually signing the will, both the witnesses must be present at the same time to actually witness the signing. So what happens when all these are not met? There is a possibility that they will be declared null and void in the event any interested parties that's actually challenging the will takes this up before the court. Next, we will go into something other than the formalities. So what are the most grounds often raised by interested parties or even beneficiaries or even the plaintiffs to basically challenge a will? So these are the points or the grounds that usually raised by parties. So lack of testamentary capacity, there are suspicious circumstances, there's undue influence, or perhaps the will was forged, the signature was forged, or the whole will is actually a fraud. So what really lack of testamentary capacity here means the testator is of unsound mind. He couldn't understand what he's actually doing. So whoever that is alleging that the will was prepared without the testator knowing it, or that testator was of unsound mind, so whoever alleged that bears the burden of proving it. So how do we usually prove what is testamentary capacity? So here will be the content of the will was read and the testator actually understood the content, the effect and the extent of the disposal of the property. So here also most often than not, where let's say the matter goes to trial and one of the grounds raised on the point of testamentary capacity. So usually also the witnesses will be called as, the witnesses that witnessed the signing will also called to testify in court. So most often than not, questions that will be asked towards these witnesses that actually witnessed whether what was the condition of the testator, whether he understands or not when all this was read to him. What was the impression given to these witnesses when they were actually there witnessing the will? Did he seem to be unaware of the will? So these are circumstances that will be raised during the proceedings to show that whether the so-called testator has the so-called testamentary capacity when actually sign off the will. This principle was enunciated in Yu Boon Yap against Yu Kian Ho. So what happened really in this case was, so the defendants really contended that at the time of the execution of the will, the deceased or the testator was 75 years old and was suffering from ill health, memory loss, there was senile dementia, which aggravated by his illness. So the defendants really contended that there was no condition of mind and there was a memory loss. However, during trial, the defendants were unable really to show all this, and the majority of the Court of Appeal accepted the validity of the will and allowed the probate to go through. Next, what else can we show here when we are challenging a lack of testamentary capacity? So we need to show medical report that the testator actually suffered unsoundness of mind or lacked the mental capacity. So these are evidence that you have to prove So we may need to call, let's say, for example, even a subsequent case like where the testator actually suffered from terminal cancer. So the issue then at Ching Chi Tian was also whether someone suffering terminal cancer, whether they have sufficient or testamentary capacity to actually prepare the will, to sign off the will. So these are a situation or grounds that usually when we are challenging a will, we have to really show that there was an unsoundness of mind. So the only way to really go about this is to get a medical report. So if you have a treating doctor who says that, yes, the patient was suffering from, let's say, cancer, but then he was in perfect memory, he was able to communicate, he knows what he was talking about, that cannot prove lack of testamentary capacity. So it is federal court decision of Ching Chi Tian. So really what happened was the court held mere bodily ill health of imperfect memory is insufficient to prove testamentary capacity. There must be a really cogent evidence to show that the testator really didn't know what he was doing in order to defeat the validity of the will. So one of the next grounds will be suspicious circumstances. So again, whoever that is raising the ground of suspicious circumstances will have to actually prove it. So usually, what is the example of suspicious circumstances? A very most common one will be where a party who takes a significant benefit under the will prepared or procured the will. So for example, someone A assisted the testator to actually prepare and even to procure the will. And under the so-called will, A is actually a significant beneficiary to the will or taking a significant huge chunk of the assets. So these are examples where a party challenging the will can raise. So for why is it helping the testator to actually prepare a will and then thereafter he's getting a huge chunk of the assets. And one method of dispelling suspicious circumstances is really to show that the testator actually obtained independent legal advice. And that's way how you can show that even though, let's say, for example, A actually helped to prepare the will, for example, but then A actually brought the testator to a legal firm, for example, to prepare the will. So that is one method to actually dispel suspicious circumstances. Next here will be undue influence. Again, a person or persons alleging undue influence bears the burden of proving it. So here in this case of Carmel Mary suicide, really the principle here is the testator was coerced into executing. The point here was the testator was coerced into executing the will in the form that he has taken, or the will was not the voluntary act of the testator. That's the point. So here what happened really in Carmel Mary suicide was the caveators of the estate, they raised the fact that the executrix was the wife of the testator. And the issue here is the relationship. And because there was a relationship point, the caveator's point would be the wife influenced the testator in giving her everything under the will. But in this case, the court held that just because there was a relationship point that was raised is not good enough to justify undue influence. So in order to justify or to succeed in the point of undue influence, really the evidence must be more cogent that the testator was really coerced and it wasn't a voluntary act. Next, we have forgery and fraud. I think this is a very common one where I guess even in movies we will always see. So what happens again, same. Whoever alleged fraud or forgery or even the other grounds will have to bear the burden of proving it. So in this situation, what really transpires would be the testator's signature doesn't bear the true and genuine signature of the deceased. That is when there is forgery. Fraud would be when the whole will was prepared, including the signature. So the allegation of forgery is most commonly raised in a situation where there are two wills. So most likely, why is there a second will? And there's evidence to show that if the signature can be shown that it's not the genuine signature of the testator, that will can be challenged. So how do we usually challenge cases like this? You have to appoint a handwriting expert to prove the signature does not belong to the testator. Here will also comes a point where the two witnesses will come and testify. If the evidence of the two witnesses is that they have actually seen it, and usually that evidence is a good evidence, even though the handwriting experts say otherwise. And that is because the witness actually witnessed it, and that is based on the best evidence rule. And this has been the position taken by court in the case of Gan Chong Chieh. I will pass the floor to Man Wei, and Man Wei will then share more insights on non-contentious and also contentious probate proceedings.
Thank you, Gan. Right, so Gan was covering one type of contentious probate proceedings, namely an action to invalidate a will. I'll move on to another very common scenario in contentious probate proceedings, which is where the beneficiaries, or sometimes even a co-executor, may initiate an action to remove an executor. So removal of executor is basically the removal of a person from his office as an executor. So probate has been granted by the court, but now there's an action by beneficiaries or maybe a co-executor or administrator to remove this person from his position as executor. Another term that's commonly used is revocation of probate. Now, because the probate was already granted by the court, but in order to remove this person as an executor, we are also revoking the probate that was granted to him. Now, this action for removal is governed by Section 34 of the Probate and Administration Act 1959. Which states that any probate or letters of administration may be revoked or amended for any sufficient cause. The court is empowered to remove an executor or trustee where there is a failure to act because of unfitness or incapacity to act. So it can be failure to act, whether intentional or otherwise. Where it is unintentional, it may be due to the health condition or mental incapacity or otherwise. Now, this Section 34 states that the probate may be revoked for any sufficient cause. So what then is sufficient cause? Let us take a look at this reported case of Ri Ku Bugong deceased. In the case of Koo Ting Seong against Teo Chui Gim and others, it's a federal court decision which held that the test of what is a sufficient cause is the due and proper administration of the estate and the interests of the beneficiaries. So in considering whether there's sufficient cause to revoke a probate, the court considers two primary factors. The first is whether there was due and proper administration of the estate by the executor. And secondly, the court considers the interests of the beneficiaries in making its decision. So this is an objective test. In law, an objective test means that it's a standard test applied and rather than a subjective test. So in this case of Ri Ku Bugong, the executor is a son of the deceased who had migrated to Australia. However, he had appointed a firm of lawyers, a prominent firm of solicitors, to assist him with carrying out his duties as executor before he left. And he did travel back to Malaysia from time to carry out his duties. So it was held in this case by the federal court that absence from jurisdiction of an executor who is always available and who has done what needed to be done, albeit with some lapses, through capable and suitable solicitors, cannot amount to a cause, much less a sufficient cause for revoking the grant to him. So in this case of Ku Bugong, the probate was not revoked and the son was maintained as the executor. Now, another prominent case on removal of executor is this case of Damayanti Kantilao Doshi and others against Jikalau Kantilao Doshi. This was a Court of Appeal decision. This is in fact only one of, I would say, a saga of many suits initiated within this family, the estate of the deceased, who is the father. The mother and the younger son were appointed as executors in this case, and the elder son, together with some other siblings, initiated a suit to try to remove the executors from their position. The respondents, who are the beneficiaries in this case, raised several points or complaints as to the issues that they're taking with the executors and why they should be removed. And in finding sufficient cause indeed to remove the probate, the court found as follows, that the executor failed to take preliminary steps in the administration of the estate. In this case, the preliminary steps in question was to apply for the grant of probate. In this case, after even a lapse of 7 years, the applicant had not filed the application for grant of probate. So the court took that into consideration, the time taken to take the first step to apply for probate. And secondly, the court also found sufficient cause in the failure to render accounts or periodic accounts. Rendering the accounts of the estate, basically, the executor needs to keep a proper record of the ins and outs of the estate. Assets coming in, who were they distributed to, any expenses paid out in respect of the estate. So in this case, there was a clear reluctance the court held by the executor to render these accounts. So that was also taken against the executor. Thirdly, the court also found that there was a failure to take appropriate steps to prevent dissipation of assets. In this case, the asset in question was a shop lot, which the court found that there was something improper, some complaints as to how the shop lot was disposed of or sold. And lastly, the point on active hostility shown towards the respondent. Now, on this point of hostility, the Court of Appeal made an interesting observation. The court held that while it is true that friction or hostility between the parties per se may not be a good reason for the removal of the appellants as the executrix and the executor, such hostility grounded in a manner in which the estate is being administered or not being administered is a matter that ought not to be disregarded. And that can be understood to mean that mere hostility, the fact that relationship isn't great between the executors and beneficiaries, may not be in itself a ground to remove the executor. But if that hostility then leads to the executor not carrying his duties properly, then you can contribute towards persuading the court to remove the executor. So in this case, the mother and the younger son were indeed removed as executors of the estate. Now, in these actions for removal of executor, the proper procedure is to file a writ action for revocation of the probate and removal of the executor. And if such an action is successful, the court will then appoint new executors to take over the duty to carry out the wishes of the testator. Now I'm going to go through some other useful tools in contentious probate proceedings, namely caveats and citation proceedings. Now, the caveat we're talking about here are probate caveats under Order 71, Rule 37 of the Rules of Court. You may have heard this term caveat before, but more in relation to land law. Land caveats function in the sense that you lodge a caveat and that can stop other people from transferring the land without first notifying you, without you first being notified by the land office. So the probate caveat works in a similar manner. You file a probate caveat in court, and this is before grant of probate or grant of LA is obtained. So once you lodge a probate caveat, and the effect of that is that no one else can then obtain a grant of probate without you first being notified. So the rules of court, the wording used is that any person who wishes to ensure that no grant is made without notice to himself may enter a caveat. And that's how the probate caveat functions. Next, citation proceedings is sometimes used as well in contentious probate proceedings. There are various forms of citation. I'll just go through this very briefly. The first is citation to see proceedings under Order 72, Rule 5 of the Rules of Court. This type of citation is filed by the applicant being the person who's trying to apply for a grant of probate. It is filed to notify persons with an adverse interest, meaning other persons who may want to apply for probate or other persons who do not agree with the provisions of the will, is to notify these persons that, hey, I'm going to apply for grant of probate now. If you would like to enter appearance and contest anything, please do it now. The second type is a citation to bring in a grant. This happens in an action for revocation of probate that we mentioned earlier, the revocation of probate and removal of executor. In this case, the grant is already obtained and the applicant is just trying to revoke the probate that's already obtained. So this citation here is to ask the executor to bring in the grant to the court registry. And the last type of citation is the citation to propound a will under Order 71, Rule 43 of the Rules of Court. Now, this type of citation is filed by a person having an interest contrary to the executor and persons interested under the will. Perhaps it can be beneficiaries or people who have not been named as beneficiaries in the will, right? Or someone else who wants to be appointed as executor but was not appointed. And this kind of citation is filed against the executor. I think that's all now. I will pass the time back to Chee-En.
Thank you, Gan and Man-Wei, for the insightful talk. I hope the participants find it useful. We will now move on to the Q&A session. Okay, we do have some questions coming in already. The first is from an anonymous attendee who's asking, how do you propose one could find out if someone has prepared a will if the usual next of kin is not aware of the same? Maybe I'll just open the floor to either Man-Wei or Mr. Gan.
Yes, I'll take this question. I think that really the short answer here is there is really no way for you to find out unless the testator actually informs someone whether he has prepared or whether a law firm has actually prepared a will. But what really we can advise client in this sense is that we can do something we call a probate search at the High Court Registry. So if, let's say, for example, a testator has prepared a will, and let's say the executor was someone else, and they could or may have actually applied for a probate. So from there, we can know whether a probate has already been taken. One, we can also then know whether a will has also already been prepared. But more often than not, after the search, nothing positive comes up from it, then yeah, really, I don't see how we can really know whether a will has already been prepared.
Thank you, Gan. There's another question from an anonymous attendee. When there are many beneficiaries to a property and half of them want to sell, while the other half opposes the sale, how can we move forward in this situation? Maybe Manwei, you can take this question.
I'm assuming that this property is to be distributed in a certain way according to the will. So if at any time we want to sell a property or distribute it in a different way that's different from the will, then we need a court order to ratify this decision to sell. But if the situation is another scenario, I'm not sure what this person is trying to ask, but if the situation is another scenario where the beneficiaries have already inherited the property and the property is already in their name and some want to sell and some don't want to sell, then again, we can go to court to let the court decide on what is the fair and just solution, whether it should sell or not.
I'll move on to the next question. This is a question from Eric Wong. 3 siblings and co-executors are beneficiaries. What happens when a sibling is not happy with his entitlement and decide not to cooperate, thus hindering and stealing the estate distribution? What can the other siblings do?
Yes, I can take this, Chian. So in situation like this, I believe this is just a very general, and I also can only give you a very general answer. But let's say there are co-executors. So certain co-executors refuse to, like what you say, refuse to cooperate, and thus hindering and also stalling the other administration of the estate. So what the majority that wants to do could perhaps apply to court to basically remove the non-cooperative executors. Then it also depends what happens there. Sometimes the court may grant, sometimes the court may not grant, but that will not only be your relief from the court. You will also seek for other stuff or other prayers, for example, depends on what act or what actions you want the other co-executors to do. Yes, so in that, one way is to remove it. Second is to get necessary orders to administer the estate.
Thank you, Gan. I hope that answers your question, Eric. Well, I'll move on to the next one. There is an anonymous attendee asking what is a vesting order and how to implement it. Gan, would you like to take this?
Honestly, I'm not really seen a vesting order in terms of contentious probate litigation. I think a vesting order usually may apply in the bankruptcy kind of proceedings. A question of how to implement it, I guess, to follow the usual execution proceedings that's available under the rules of court.
Okay, thanks, Gan. The next one is from To Min Rick. There is a question from him asking about contentious proceedings. If the challenge against the revocation of the will or the revocation of executor is successful, who bears the cost? The executor or the estate?
Yeah, okay. Usually in standard civil proceedings in court, the losing party bears the cost. So you're asking, okay, in this case, the executor has become the losing party. I suppose in drafting the prayers for relief, in filing this contentious proceeding in the first place, we can ask that cost to be borne by the executor personally. We can spell it out specifically to avoid the estate having to bear the cost. In fact, in certain circumstances where the conduct of the executor is of such bad faith, the court can order that the cost to be borne personally. Thank you.
Thank you, Manwei. Moving on to the next one, there's also a question about asking what is considered a reasonable time frame to execute a will.
I stand to be corrected. The reasonable time or time given under the Probate and Administration Act will be a year. Anything after that, you just have to explain the delay in applying for a probate. So there is really, when you say execute here means to comply with the will, there is really no timeline, but to apply for a probate, you have to do it within a year.
Maybe I can just clarify a bit on that. I think maybe initial steps, as Gan mentioned, to apply for probate should be done within a year. And the explanation only becomes mandatory after a lapse of 3 years. So this is in respect of the application for probate. But we shouldn't wait too long in terms of distributing the assets or carrying out the executor's duties, as we've seen that the Doshi case, the Doshi estate case just now, after a lapse of 7 years, it is taken against the executor. Thank you.
All right, thank you. Moving on to the next one from Ang Kai Wei, who's asking, can we file a writ instead of applying for citation, or is a citation a must in any contentious estate proceedings?
Oh, a citation is not a must. The citation is only used in those certain specific circumstances. In fact, I would say, drawing from my experience, that it is rarely used. Maybe Gan can correct me if I'm wrong as well. But generally, for contentious probate proceedings, the correct procedure is by writ action, so that it can go for trial and witnesses can be called. Thank you.
Okay, we have one more question from an anonymous attendee. He's asking, I bought a condo in JB and thought the property will be owned jointly with my wife under joint ownership as in Singapore. Is it true, and is that true? And if so, can I make a will for her to own fully at your offices?
I think I just answered this in the perspective of a will. You can actually prepare or even get your will drafted, whether it's Singapore, JB, or KL, as long as it complies with the formalities which I've shared here in my slides today. So long you have complied with the so-called formalities, then yes, even you have a condo in JB, then upon your demise, your executor actually apply the probate in Malaysia. Let's say even you have assets in Singapore and also in Malaysia, what you can also do is you can apply either in Malaysia or even in Singapore, and then you get it resealed, the probate in either one of the jurisdiction. Or you can also do two wills, one in Singapore, one for Singapore assets and one for Malaysian assets. Then you can run the application for probate concurrently in both the jurisdictions. Yeah, I hope that answered the question.
Thank you, Gan. Before we conclude, I do have a few announcements to make. The first one is talking about our next talk, which will be on the 26th of July for those of you who joined later on. As I mentioned earlier, we have another talk on the 26th of July titled Legal Challenges in the Dynamic World of Technology. This will be conducted by one of our partners. I believe this will be relevant in today's world. I hope everyone can tune in to this upcoming talk. You can scan the QR code here in the slide to sign up for online talks. I'll just leave it here for a few seconds so that you can scan the code and then just sign up from there. The next announcement that I want to make is to ask the participants to please fill in our feedback form and tell us what you thought of our talk. The link to the form will be posted in the chat. I believe it has already been posted. And also, please do follow or like our social media accounts. We have a YouTube, Twitter, Instagram, LinkedIn, and Facebook. Now, if you have any further questions that you want to ask and you would like to speak to our lawyers, we offer a complimentary 30-minute consultation over the telephone or over video conference. Please fill in the form on the website. I believe the link has just been posted in the chat box, or you can also scan this QR code to schedule a meeting with our lawyers. Thank you, everybody, and I hope you found today's session informative and useful. We hope to see you in the next talk.